Hello and welcome to the I Got Fired podcast, a podcast for people who've been fired or afraid that they might be. I'm Tom Spiegel, founder of the Spiegel Law Firm and host of this podcast. So we are continuing our series on the processes in litigation, and by that I mean you filed a complaint in court and you're now in court. The first one we talked about, the starting gun when you filed your complaint. And we talked about the necessary step of serving your complaint on the defendant so that the case actually gets going. We talked about the answer, the response from the defendant after they have been served. And we talked about motions to extend, which can occur at any point during the litigation's process. And then today I want to talk about something called a motion to dismiss. But before we get into that, a little bit of legalese. This is intended to be for educational purposes for you, the listener. It's not intended to be a legal analysis of your claims or to form an attorney-client relationship with the Spiegel Law Firm. If you want specific legal advice for your case, you got it. Go hire a lawyer, or at least set it. Have an hour-long consultation so you can get some legal analysis of your case. All right, so let's talk about motions to dismiss. So after you filed the complaint, and remember now this, if you're in a typical employment case, you've been at this for a while, right? You've hired the attorney way back when. You sent the demand letter. That didn't work. Maybe you had some mediation. That didn't work. Went through the EEOC process, got your right to sue. You filed your complaint within that 90 days. The defendant has 21 days to file a responsive, what they call a responsive pleading, and they perhaps have asked for an extension of time and have gotten it. So we're now, you filed your complaint. 2 months after that, you may be a year or more into this process. So just as an aside, important thing to consider if you were starting a case is that it's not, pell-mell, immediately, all the way through. There are, specific times when there will be a lot of action in your case, and then could be, sometimes months and months of waiting, good and bad. Obviously, you'd like to get this done sooner rather than later, but it also means if you're the one trying to fund your own case, that it's not like you have to come up with that money all at once, that this process can take a while, and also settlement can occur at any point along the process. But for today, we're assuming that has not happened, and you get what's called a responsive pleading after filing your complaint, and you get what's called a motion to dismiss. And for those of you who are following along in the federal rules of civil procedure, it's Rule 12. That's both for the answer and for the motion to dismiss, because the defendant can file either one. The defendant can file an answer, or can file, or both, or can file, often be one or the other, or a motion to dismiss claims. So a motion to dismiss, and if you look under Rule 12, there are any number of motions that a defendant can file at this point. The most common one is a 12B6, is a motion to dismiss, which basically means like they haven't even stated a legal claim here, Judge. And so there are a couple of points in the litigation where you can get your case either entirely kicked out or partially kicked out, and this is one of them. Now, this one is a much lower bar or let's say a higher bar for a defendant to meet to kick your case out, because the standard that a court will apply after your complaint has been filed, if there is a motion to dismiss, is the judge is going to look at that, and he or she is going to assume, as they're required to do by the federal rules of civil procedure, assume that everything you say in your complaint is true. They're not getting into fact finding at this point. That's for a later point. They're just looking at what you've said in the complaint. Does this state a claim? Just to give you a silly example, like you could file a complaint that says, you went to your holiday party and that your boss was there and she was rude to you. Of course, you wouldn't file that for the purposes of this. That you have. Somebody has filed this. And obviously, you don't have to be a lawyer to know that it's not illegal for someone to be rude to you. Impolite, yes. Illegal, no. If you have filed a complaint that says, you laid all this out in great detail, it's a 36-page complaint, the judge is going to, the defendant would probably file a motion to dismiss and say, essentially, Your Honor, even taking everything this claim as true, the plaintiff has not stated a claim. You need to kick this out. Um, it's within our practice, hard to say. I would guess about 25% of the time, you'll have a defendant file this. Sometimes they've got a legitimate, argument. Sometimes they're just trying to run up your bills, the plaintiff's bills, or to buy time. But in any event, about a quarter of the time, you will see a motion to dismiss get filed. And then what happens is that you will have a time to respond to that with your reply. It might be with your where it's called an opposition to the motion to dismiss. The other side may get a chance to submit a short reply, and then that usually ends it. There's sometimes the court will allow the plaintiff to file what's called a SIR reply, which is basically a reply to the defendant's reply to your opposition, but that is fairly rare. So usually, defendant files the motion to dismiss, you get a chance to file an opposition, and then the defendant, if it chooses, can file a short reply. And then usually the case will be set for oral argument. By that I mean you show up before the judge and you argue your case. So what does this look like in employment law? An example might be, you filed a complaint, and let's say you are alleging that your former employer defamed you, said something that was untrue about you and damaged you. And in the complaint, you file it and you allege defamation, and you set forth what the defendant said about you. You state that it's untrue. These are both things that have to be, in a defamation claim you have to have, but you didn't include something in there that said that this lie was communicated to someone else. Right, it wasn't just communicated by your former employer to you, but it was communicated to a third party, which is what you need in order to have that claim. And you didn't put that in the motion to dismiss. Maybe you just forgot. Maybe you didn't know that was part of the claim. And the defendant files a motion to dismiss and says they haven't stated a claim here. And let me say also, for a motion to dismiss, it may be to just part of your complaint. Maybe they just file a motion to dismiss. Let's say you have, 7 claims, then the motion to dismiss is just for 3 of them. So this goes before the judge, and the judge is looking at this, and has to assume that everything in the complaint is true, and says, does this state a violation of the law? And this is, again, a higher standard for the defendant to meet. I sort of think about it like when you're going to ride those roller coaster rides, and says, you have to be this tall, to be able to ride the ride. For a plaintiff, you are often going to be the plaintiff to beat back a motion to dismiss. It's on the shorter end, right? Like you only have to be this tall to ride this ride, and you, the plaintiff, you have just had to you have to file a complaint that sets forth facts and a claim, and you have to hit every element of that claim. So, for example, defamation, untrue statement communicated to a third party, and it caused you some kind of damage. And if you fail to state that, if you fail to have that in the complaint, the court can grant the motion to dismiss. Now, the good thing about losing at that stage is that what the court will usually do is dismiss it without prejudice, which means you can file it again, and that's not uncommon. The court, may look at it and say, you didn't state this third claim. If you've got evidence to that effect, I'm going to give you, it's usually 30 days. I'm going to give you 30 days to refile your complaint and cure this provision. Now, if this happens a number of different times, the court could grant it with prejudice, which means you're out. Your only option now is to appeal it. So at this stage, it's rare that you're going to be kicked out of court completely. And sometimes, sometimes as a plaintiff, you may look at it and be like, well, you know what, they're right. And so we're just going to submit an amended complaint. We're going to file an opposition, and as part of that opposition, we're going to attach an amended a motion to amend um, the complaint and cure whatever the deficiency is in your complaint, the factual deficiency. So that's a motion to dismiss. It's like I said, under 12b6. It will be the first thing that it'll be what's called a responsive pleading. You filed your complaint, so rather than answer, they'll file a motion to dismiss. And if the defendant loses, then they go on. They give some additional time to file the answer, and they file the answer, and you go on the case as usual. It's hard to know whether you're going to get a motion to dismiss or not. There's usually no way to predict that unless you're like you're filing some kind of novel claim, and the defendant is going to try to kick it out the motion to dismiss. Which just points to the fact that when you're trying to predict the cost of litigation, sometimes it can be difficult because as you're filing the complaint, you don't know if the other side is going to file a motion to dismiss. And obviously, if they file a motion to dismiss, your attorneys have to oppose it. This is not. We'll get to summary judgment later. It's usually not really a lengthy filing. It's not like you got pages and pages, although sometimes they can get pretty complicated. But nevertheless, it's a certain amount of work to get that done. And again, if there's going to be oral argument before a judge, everybody's got to show up, and you got to have the argument, and that's before you even get to the answer. So again, you don't know whether you're going to get a motion to dismiss. Your attorney's not going to know whether you're going to get a motion to dismiss. It's just one of those unknowns of litigation, and this happens multiple steps through the litigation. The being able to try to predict how long it's going to take, how much money it's going to cost you. An attorney who's done this a lot can give you a pretty decent ballpark, but again, your attorney doesn't know if the defendant's going to file a motion to dismiss. Your attorney doesn't know if the court's going to grant it, and you're going to grant it. You're going to have to file an amended complaint. These are all twists and turns that litigation takes as you go through the process, and often it is difficult to determine going into it how many of those twists and turns you're going to face. So there you go. There's a motion to dismiss. Keep in mind that I think it's important for you to know this, and particularly know that it's usually not a death sentence for your case. I mean, it can sound intimidating. And we certainly have had clients, you get a motion to dismiss, and they're like, this sounds terrible. I'm going to lose it all. It really can be jarring to get one of those filed, but know that it's not uncommon. It's not, you can't win every one of them. It is true that sometimes defendants win it, and sometimes they win it in a way that kicks you're not going to be able to come back from. But for the most part, at least a portion of your claim your case is going to survive, and maybe all of it. So just know that this happens in your litigation. It's not the end of the world. It happens fairly frequently. Courts deal with this every day. And if you've got an attorney and you have set forth a good complaint, your chances of winning that are pretty good. I did have a client a number of years ago who had she was representing herself pro se without an attorney, smart woman, and had filed the complaint on her own and went to the defendant, filed a motion to dismiss. She showed up to court to argue herself, which took a lot of guts, that's for sure. And the judge looked at it and said, I'm going to grant this motion to dismiss. I do think there's something there. You essentially need to go find a lawyer. I'm going to grant this without prejudice and give you 30 days to refile it. It's a technical part of the rule of civil procedure. It's important to know how it works and how to come back from it. That's all we got for today. The next time we're going to be talking about discovery, which is the next stage where you get into the facts of the case. We're going to have one episode on paper discovery, and then we're going to have another episode on depositions because they function very differently in a case. If you would like more information like this, you can go to our site, thecareerrocket.io, where we will share the latest and greatest tips on employment law and also other material on how to keep your career on an upward trajectory. Anyway, good luck out there, guys.